Hey folks, and welcome back to another update about the developing income store situation. I know it's only been a week or two since my last update, but I realized I was notified after my last video in the comments on the video and also via direct message that many people were not getting updates, that the documents we're talking about here on the screen are not making it to the income store receivership website. And while some of them may be getting emailed out, they're not coming out very quickly. So I took a look on Pacer today and there was a little bit of fireworks. To me, it's extremely interesting from the legal side, but it also signals that we may be looking at finally seeing some movement, some things progressing. First up, we're looking at the docket entry on the criminal case against Ken Courtright. It notes that the docket entry was made on September 21st, and as I'm recording it, it is the 23rd, so this is within the last few days. The things that are important in here to note is that pretrial motions are due in December, and that trial is actually scheduled on this criminal case for January of 2022. Now, as I'm looking at that, I really hope that 2022 is a typo, considering that defense pretrial motions are due December 31, 2020. As I'm reading this, I'm making the assumption that they actually meant 2021. Again, because motions are due at the end of December in 2020, and they even need to have a discovery status report at the beginning of November. Now, does this mean because this docket entry states that the jury trial is set for a specific date, and again, we're assuming it's 2021, that it will actually happen? Odds are probably not. It is not uncommon for trial dates to be reset multiple times, as long as there is good reason. Still, this is the first time that we have seen any sort of date scheduling that could give us some hope that this case would actually progress. And again, we'll remember that Ken Courtright is now being represented by a public defender, and that could go two ways. Many times when you have retained counsel, there is pressure to get through to the trial to stop the bleeding of money being spent. A defendant will want to get things done just so they can actually afford what's going to happen. But when a defendant is not paying the legal fees, they may not have that intensity, that urgency about getting the case wrapped up. And if somebody is looking at a situation that is fairly dire, if they think that they may be looking at a term of imprisonment, there's generally not a lot of incentive on the defense side to hurry things up and get there. Now, let's move on to the SEC case. There was a motion filed last week, and it was called a motion for approval of a contingency fee arrangement. Now, this may not sound exciting to you at all, but to me, this could be considered a shot over the bow. The receiver basically knows at this point that there's no money. And I'll tell you one thing that demotivates attorneys just about more than anything is doing work when there is no money there. In that usual case, they're gone, they're out of there. One of the things that we've been talking a lot about is whether or not the receiver would be pursuing any of the third parties that were involved in this whole, alleged scheme. And thus far, the receiver has been paid on an hourly basis. They account for their time and then they go ahead and file a motion and seek approval. And now they want to go ahead and go to work, potentially prosecuting claims against third parties based upon their involvement with TGC. A contingency fee arrangement means that if the receiver manages to recover money for the investors, that they would take a cut of it. And if they don't recover anything, then they don't get paid anything, with the exception potentially of getting their expenses advanced repaid for if it's possible. Things like documents, experts, and such. The last several months have left investors and people who are following questioning whether or not the receiver would be pursuing any third parties at all. In this motion, it notes that the receiver has discovered that various third parties have assisted, aided and abetted, enabled and facilitated the fraudulent scheme ran by TGC by allowing TGC to steal millions of dollars from hundreds of victims across the country and misuse, divert, and appropriate the investors' proceeds, all through the bank accounts of these institutions with their knowing and negligent assistance. The receiver has also uncovered transfers that are voidable under the Illinois Uniform Fraudulent Transfer Act. While the receiver has not concluded her investigation of the merits and viability of the contingent claims or the collectability, the receiver proposes to continue her investigation and, to the extent that they discover viable claims, bring the contingent litigation claims to recover funds for the benefit of the estate. Now, some people may be grumpy about the idea of a contingency fee agreement, especially since the percentage of the contingency fee is quite large. 30% of all gross recoveries received by the receivership at any time time before the commencement of the action, which usually means filing documents in court, or 33% after documents have been filed in the court. That would take a large chunk of money out of the pockets of investors if this order were entered and agreed to by the court. But for investors who really have no other alternatives, the state doesn't have basically any more money, and people aren't going to be pulling money out of their pockets, probably the only way that these types of claims would go forward. I mean, the upside for investors is that if the receiver doesn't recover money on these claims, that the estate won't be on the hook to pay them hourly for that. And basically what these lawyers will have to do is just very carefully keep track of the time they spent on the administration of the estate and on these claims. In the conclusion of this motion, the receiver requests entry of the order approving the contingency fee arrangement provided in connection with pursuing the claims against insiders, affiliates, or third parties. Insiders, affiliates, or third parties. One of the things that we've talked about a lot is whether or not affiliates or recommended TGC would be pursued in any way. And I question whether or not the word affiliates in this motion actually means what some of us think in the world of affiliate marketing would assume that it means, because affiliates could also just mean associated people. I think there's a lot of folks out there who are just putting their heads in the sand and assuming that this wasn't going to go anywhere, or just hoping that it wouldn't, especially people who were paid large sums of money from TGC for their participation in referring business to them, especially potentially in the 12 months before everything imploded. I would also note that they conferred with the SEC attorneys who did not oppose this motion, but the Receivers Council conferred with Ken Courtright about the requested relief, and Courtright informed counsel that he actually opposed this motion. Now, we know Ken Courtright at this point is pro se, meaning he's representing himself, but I have to wonder, why would he oppose this motion? What motivation would he have to say, no, court, I do not think that this motion should be granted? One, he might not want the estate to be committed to paying out potentially a third of any recovery. Maybe think that that's just too much money for the lawyers. Or maybe he doesn't want the receiver to go out there and be suing potentially his friends and former business partners. Do we know for sure that the receiver will actually file suit against any third parties or other insiders? Nope, no idea. But for the benefit of the investors, we can only hope that this is the first step in the right direction. And we have to make the assumption that the lawyers think that this is a worthwhile endeavor if they are willing to risk their time and put their money up front to pay for experts, because the estate is basically bled dry at this point, to pursue these types of claims. And that's what I got. If you are coming to the Income Store story and this is something new to you, take a look there on the screen, and what you will see is a playlist that covers all of the videos that I have made, basically taking you through from beginning to end what is going on with this developing story.